Good evening. This is Rahul Reddy live here from Houston, Texas. Every Tuesday at 5 p.m. Central Time, Reddy Neumann PC does bring in immigration updates. Along with me today is my business partner, Rebecca Chen. Rebecca, what do we have today? I mean, what's going on in the Congress?
Yeah, a lot has been happening. Clearly, kind of a disappointing end to the topic that we've been covering the past 2 to 3 weeks, the most HR 1044. So we'll discuss that and where we go from here on HR 1044, delays in the issuance of I-485 receipt notices that were filed in October especially. We'll discuss a bit about the proposed rule for changing the H-1B registration requirement. That's for the lottery that's coming spring. And the stimulus bill that was just passed in Congress and what it means for non-immigrants, especially H-1B and H-4 non-immigrants. So starting with kind of the topic we've been discussing the last couple of weeks, HR 1044. Rahul, what?
It's definitely not good. The battle is over. We got the first question from Vijay asking, is the bill dead, sir? The battle, we lost the battle. We had lost many battles. This is another battle we lost. But the war is still on. So even though this Congress session is over, there will be a next Congress session coming on January 2nd of 2020. The new administration has promised us that they will take the discrimination off. We have to see how it's going to work out. I have seen Bush administration trying to take it off. They couldn't. Obama administration tried to take it off. They couldn't, especially in this congressional session, though. I have seen two congressmen, one Joe Lofgren from California and also Mike Lee from Utah. They worked very diligently. They worked very hard. I thank, and on behalf of everybody, I thank them for the efforts they have done, for the things they have done, for the sacrifices they have done to get this bill going on and get this thing passed. But I would, at this point of time, say that the main blame will go to Rick Scott, the senator from the Florida, to blame, and there are other people to blame. But at this point of time, I want to take the leaders that were supported this one, especially Joe Lofgren from San Jose's congresswoman, and also Mark Lee. They did the best they can. We lost the battle. We will have to fight the battle again. A lot of people are saying that it's Joe Lofgren, it's because of her we lost the battle. Absolutely, I disagree. She is the best captain we had. She is the best lady that we had. It's not her because of which we lost. It's because of us. We have to all blame ourselves too for not contacting the congressman, not contacting the senator, not putting in enough efforts. Not Joe Lofgren, I would not blame. She tried, even with all the diluted, when the bill passed in the House, not many provisions were there. It went to the Senate, it got diluted so many times. We had Senator Rand Paul coming in saying, hey, I want to do, I want to add this healthcare bill, and he stopped it for a while. Then we have the senator from Illinois that stopped it, and we had senator from Georgia that stopped it for a while. What was the Georgian senator? I forgot it. And then we have Rick Scott from Florida, who put the last nail, and definitely we lost the battle at this point of time. This Congress ends on January 2nd. There is no schedule of HR 1044. There is no schedule at all right now for them to meet. There's no schedule at all for them to meet at all. So the chances of anything could happen is almost absolutely nil. I mean, less than 1% though. I would recommend everybody to thank the congressmen, senators who have supported this bill. Thanks for all the efforts what they have done, and let's start the battle again. The new battle will start on January 2nd. So be prepared for it. Any comments on it?
Yeah, just the same. We, you know, understandably, a lot of people are very disappointed because we were the closest that we have, you know, ever been on this legislation. Something that would affect so many people. But as Raul said, you know, we want to encourage everyone to not give up. You know, the comments that you sent to the Congress people, those that did contact their representatives, you know, don't think that those were in vain or a waste. The more that we can educate the representatives on this issue, you know, the further along we will be the next time we take up this issue.
Well, when the adult suffrage came in for women, when women's rights were being fought, they fought for decades, and there are some places still the women are not allowed to drive. So yes, there is discrimination in many fields. The women fought for a long period of time. They won. Then we had the colored people that fought for a long period of time. They won. We had the gays and lesbians fight for a long period of time for getting the equal treatment. They didn't want any special treatment. The women did not want any special treatment. The colored people or African American people, they never wanted any special treatment. They wanted to be treated equally. It took a long time. It took a long time for them to achieve their things, and it's going to take a long time. One of Dr. Shinaj was telling that, yeah, it is David Perdue who put the hold on this bill for a while, delayed for a while. That is right. Yeah, we are going to face the obstacles, but don't give up. Let's start fighting again. You know, relax for a while so that you can be prepared for fighting another battle starting from January 2nd. Anything else? Rebecca, what's going on the 485 receipt notices? I mean, the applications filed in October, some people are saying they didn't receive a receipt notice. What is your comment on it?
Yeah, that is very normal. If you have not yet received your receipt notices for I-485 applications filed in October, they are kind of trickling in very slowly, and it definitely looks like the applications that were filed as an I-485 application alone without a concurrent I-140 petition, those are getting the receipt notices first from our observation. And yeah, it's going to be, you know, we knew it would be a long process for USCIS sending the receipt notices for all the applications that were filed in October. So if you haven't gotten yours yet, it's not unusual. They are starting to slowly trickle in, so just be patient.
A lot of questions are coming with regards to the bill, which we're going to address some of those things. Some people are asking, will it be introduced as a HR 10044, or will it have to start all over again? Unfortunately, we'll have to start all over again. That's one thing, unfortunately. The questions that came up was, hey, can this be issued in an executive order? Executive orders can be issued for certain things, but for getting the elimination of the entire priority per country limit, though, it has to go through the Congress. They can't do it by the executive order because it's contradicting the Congress. You know, in most of the countries we call it as parliament. We call it as Congress here. So since it came from the Congress, the executive order cannot contradict it. However, though, it's a good point you guys have raised, is that there are two provisions of the bill in the 1044. One was the priority dates becoming current or moving based without discriminating based on the per country limit. The second one was actually that if the I-140 was being approved for more than 2 years, you could file the adjustment of status and be independent of the employer. This can be achieved the second one, where filing the I-140 without priority date being current after the I-140 is approved for more than 2 years. That can be achieved while Congress is sleeping. they're not acting, they're not voting, that can be achieved. And I just want to explain some of the legislative process, how it works out, especially in the Senate though. House is a little bit clear where there is a simple majority that works out. When it comes to the Senate though, they do have a filibuster rule and they do have a hold. These are unconstitutional according to me. I mean, it's not been challenged, but they're unconstitutional according to me. We hope the new administration is going to come and change the rules of the Senate, which actually cannot be changed by the administration. It has to be changed by the Senate itself. Maybe they'll take off the filibuster and putting the hold. Maybe the majority, the vice president with the majority, assuming that they will win the 2 senators from the Georgia. Maybe they can change the filibuster rules. But it is very disappointing. The rules are so complex in the United States, especially in passing the bills. It's not that easy, even if they have a simple majority. When the Constitution only requires that we need to have only simple majority in both the houses to pass a bill. Even though the Constitution says that the Senate takes it differently. They don't want to do it that way. They add extra rules for themselves to make them important. The Constitution only gives veto right to president. It does not give a veto right to each and every senator in the United States. But they themselves have given the rights for themselves, so any senator can put a hold on it. And that's the reason why the whole problem has occurred. Rebecca, let's go to the regulations, and there are more harder things coming. This administration is not over yet. Trump administration is going to be out of power starting from January 20th of 2021. And there are some regulations that were being, the proposed regulations were being published. There was a comment period of 30 days that was over. And this administration, before going out, can still harm some of the non-immigrants. Now, Rebecca, what about this wage-based H-1B quota? Can you explain what this is and where the process is?
Yeah, so this is a proposed regulation that was, the proposal was issued November 2nd, and there was a 30-day comment period that ended December 2nd. What this rule proposes to do is to give priority in the H-1B registration system, which is the lottery that would occur in March to decide who is selected to submit an H-1B application in the CAP. It would give priority to H-1B beneficiaries who have the highest salaries. So instead of the current system where the only kind of advantage is for recipients of U.S. master's degrees who have, an extra 20,000 H-1B visas set aside for those individuals, the proposal would prioritize applicants based on the salary offer that they have. And in effect, it would basically block out anyone who has a level 1 or 2 category wage, and anyone who has an entry-level wage according to their occupation in their geographic area. The prediction is that it would, in effect, block out anyone in those categories, and that basically in order to be competitive in the H-1B registration system, your employer needs to offer you a level 3 or 4 category wage. So this proposal, now that the comment period is over, it is possible for the final rule to be published any day now. There have been a lot of comments submitted concerning this rule from not only non-immigrants or the employees who might be affected, but from business groups and from a lot of groups pointing out how problematic this kind of rule change would be. We will need to see how much DHS takes those comments into consideration before going forward with the rule. We know that the intention of the administration was to put this in effect for this upcoming lottery season, so March 2021, which is not very far away. So if that is their intention, then they will need to publish a final rule, relatively soon. I would say in the next month or so, if that is their intention.
So especially if the new regulations will become effective, you may have to plan your life around it. For example, if you're working in San Francisco area, to get into the higher wage level, it may be tough. Maybe you should request your company to transfer it to maybe a remote place in Texas where your salary might be same, but when it comes to Texas, your salary may bump up to level 3. And if your job duties meet the level 3 requirements, then bump up your salary to the level 3, then you will be in a better position to take these positions. But I'm not sure if all these things can be worked out, but be aware that these things may be coming. So it may be tough for the people whose level of salary is level 1, level 2. They may be having a tough time in getting the H-1B through the lottery system if this new regulation goes through. Let's speak about some good news. Rebecca, we always tell the bad news. What about the stimulus check? Our H-1Bs, L-1Bs, are these eligible for the stimulus check that the Congress passed?
It seems so. So the second stimulus bill was just passed, so it's still being sorted through and reviewed for the contents. But from what we know so far, it does appear that H and L workers are still eligible for this second round of stimulus checks, and that it won't be considered part of the public charge in the same way that the first round was. So anyone who is in H or L status, basically anyone who's classified for tax purposes as a non-resident alien, should be eligible for this second round of checks. It also seems from the language of the bill that one sort of effect of the first CARES Act was that sort of mixed households where one individual had a social security number and the spouse had maybe an ITIN and tax identification number. Those households, even though one person was eligible for the stimulus check, if they had filed their tax return jointly, it meant that the household as a whole did not receive the stimulus check. It seems that that kind of maybe unintended consequence was sort of fixed in this second stimulus bill. So it appears that that should not be the case anymore, that if one member of the household who filed jointly is eligible for the check, then he or she will still receive it.
There are a lot of blame game going on right now. Who killed the bill? I stand with Joe Lofgren. There are some statements I've seen people posting in this link saying they're cutting and pasting just one point of what she said. They're not pointing out the entire statement what she has made. She was willing to get this bill out as it is passed in the Senate, even though she disagreed with some elements of what went on with the Senate, but she couldn't do it. Even she can disagree with some of the things that were there on the Senate version. I mean, the phase-out period is 10 years. I didn't like it. Why does the discrimination has to be phased out in 10 years? That doesn't mean that I personally did not support this bill. Just like the way Joe Lofgren, you're making, some of the people are cutting out some of the statements she has made that she disagreed with the Senate bill, saying that she killed the bill. She is an architect of the bill. I mean, if I don't know what to say. If somebody has an opinion of Joe Lofgren, there are people who have opinion that we killed the bill. I mean, everybody has their own opinion. You do, but according to my opinion, I have, in the bottom of my heart, I have high respect for Joe Lofgren. As far as the Stephen Miller is concerned, I have no respect, and none whatsoever at all for him. As far as the Rick Scott of senator from the Florida, definitely, according to me, he and Stephen Miller are the people culprit. That is my opinion. If you guys have an opinion on somebody else, that's up to you. I see people are blaming, everybody's blaming. Some people are blaming Joe Lofgren. I disagree with them. I definitely don't think so that she will ever do that, and she did not do it. That's my opinion. a lot of questions are coming with regards to the 485 process. How long it's going to take for the EAD, advanced parole. It may take up to 10 to 12 months nowadays to get the EAD and advanced parole. Hopefully, the new administration may make it very faster. Based on the previous history, this administration, because he was the part of the Obama administration, they didn't do any expedited things before though. I hope Joe Biden will be different than Obama, because we used to call Obama the deportation king when he was the president. I hope this guy will focus more on getting the business immigration on track and moves the things. There are simple steps that he can do to get these things processed. He can remove the biometrics for a lot of people. He can remove the form called a 944. He can ease some of the processes to get this thing faster. I have seen Bush administration when he came in, he requested all the USCIS to expedite things. He told them that the time things have to come down. So for example, if a process was taking 12 months, Bush administration told them in 6 months, I want the process to come down. Guess what happened after 6 months? The 12 months process went to 14 months. And this is what Bush did, President Bush did. He fired all the district directors. He didn't fire them immediately. He fired them 6 months from now, you're all fired. All district directors fired. Guess what happened in those 6 months? Oh, they were working on Saturday, they were working on Sunday. Oh my goodness, we have to go for adjustment of status interviews on Sunday. Saturday, early morning, 5:55 a.m. And they cut down the timings by about 80% of the time. So I hope this new administration is going to take from the Bush administration and will try to cut down the times so that it comes to, he can cut the time. A lot of things, H4 EADs, H4s, adjustment of status applications, EADs, advanced paroles, they are taking a lot of time. And guess what the administration is telling us, the Trump administration? We don't have enough money to work on it. Why you don't have enough money to work on it and you're backlogged by so much? Because you have created a lot of hurdles in your own work, and that's the reason why you're delaying all these things. I hope this new administration will change and will try to bring the process faster and better.
Yeah, speaking of processing times, there are some questions about the expected processing time of the I-485 applications that were filed in October. Unfortunately, we don't have a very optimistic outlook on the processing time for those applications, unfortunately. For one thing, there was, as this person mentioned, kind of a flood of applications all at once. So whenever there is a large number of applications, such as the CAP subject H-1B applications that are filed every year with USCIS, we do see USCIS taking quite a long time to make their way through those applications. In addition to that, this year has presented additional obstacles or additional hurdles to processing times. For one thing, I-485 applications require that each applicant be fingerprinted, so you have to go in for biometrics, and USCIS is still quite behind on those biometrics appointments from the ASCs being closed for several months this year due to COVID concerns. It seems like they are still making their way through the backlog of applications that I-539 applications that were filed over the summer for B visas. They still have a lot of catch-up to do on those biometrics, so that's one thing that is already going to be a slowdown to the I-485 processing, unfortunately, just getting your biometrics scheduled. On top of that, we will have to see if USCIS decides to continue its in-person I-485 interview requirement. So that is still technically a requirement. They have been waiving it in some cases that are very near the end of the I-485 processing time. So we have seen some I-485s over the past few months being approved without requiring the in-person interview due to COVID concerns. But over this next year, if whether USCIS field offices continue that policy or not may also affect processing times quite a bit, because that is also a significant factor. If everyone still needs to be interviewed and they're staggering interviews or reducing volume at the field offices the way they are now, we can expect that processing times will still take quite a while. I am predicting at least a year, possibly, or more. That could vary based on field office jurisdiction.
People are asking that if we can sue the administration for the discrimination based on the per country quota. It has been tried before. This is not the new one on other issues in the immigration. Unfortunately, Supreme Court did not stood with us. The Supreme Court stood with the government, and they said that people can be discriminated based on their birth. And now when it comes to the US regular laws, it's very clear that you cannot discriminate based on the birth of a person. So we require Congress to change these discriminatory rules. That's what is the practical method. Had it always been the Congress that did it, for example, when it comes to gays and lesbians, it's the Supreme Court that stepped in. It's not the Congress that came in. That completely take the discrimination off. So, however, when it comes to the immigrants, though, certain provisions of the Constitution are not applicable. We may not have the equal rights compared to the U.S. citizens. So that's where the discrimination, to an extent, is allowed. According to the Supreme Court in the immigration, it has been tried before. Yeah, it could be tried again. Maybe things changed right now. But the way the court is right now, the Supreme Court, where how the Supreme Court justices are right now, where normally it used to be 5-4, we used to have a swing vote, and right now it seems to be that it's 6-3. So the chances definitely are very less because this will go to Supreme Court. I mean, this will not happen in a district court. District court, it will go to the Supreme Court, any of these things. So my thing will be that, yeah, it will be a very weak case. We should keep trying with the Congress right now, again.
Some other I-485 filing questions. So Vishal from YouTube says that his spouse's I-485 application was rejected, but his was accepted. It sounds like they were filed concurrently, maybe in October, and is asking whether he should try refiling now or in January. So the visa bulletin for January still isn't out yet. It seems to be a matter of course now for the Department of State to just issue it as late as possible in the month now. So we don't know yet if, what the dates will look like in January. So if it is possible, Vishal, I would recommend that you try to refile this month, if possible. It's possible that in January it may still allow her to submit her application, but we just don't know for sure, and we don't know when the visa bulletin will be published. So if you can't, go ahead and file it in this next week.
Kapil Sharma has a statement that I want to repeat. We don't want stimulus, we want equality. I completely agree with us. We happily would give up that stimulus check, and not only that, we are willing to pay extra $2,000. That is what is required when you file a 485J supplement. And I don't think so anybody opposed that to add the $2,000 extra burden on us. We were fine. I mean, we would be happily not take the money and pay extra $2,000 to the government. We would be happy. I hope the Congress understands that.
I've seen a few questions about kind of the PERM processing time. So that is also increasing, unfortunately. Actually, PERM processing times are the longest right now that we've observed in the past several years. It's at about 6 months once it's filed. So our most recent approvals have taken about 6 months from the time they were filed with the Department of Labor. And prevailing wage determinations are also taking quite a bit of time, about 4.5 to 5 months. On top of that is the mess of the attempted increase of the DOL wages earlier this year, a couple months ago, that we're still sorting through. So yeah, unfortunately, PERM processing times are also at an all-time high at the moment, and we don't necessarily see that decreasing anytime soon, as a lot of people are submitting their PERM applications, and at this time, DOL is still not, the PERM is still not a fee-based process, so there's no premium processing option yet, although that has been proposed and would probably be very welcome.
About the bill, people were asking, Dr. Shanaz is asking, can this bill be introduced in January again? Yes, this should be introduced in House for sure soon, especially with Joe Lofgren, still the Congresswoman, going in the next thing. It will be introduced soon. I'm not expecting much problem in the House. The House bill will be fairly simple. Just take the per country quota limit off and probably phase it out. They will not directly do it. They will always phase it out in a period of years, which should be fine for us to bear the pain a little bit more. But it's a Senate that we have a problem. It is the Senate that we have a problem. We still have Mark Lee in there. He's going to be the senator continuing, so we should still thank him and see how he can manage the Senate. He has fought very hard in the Senate. Joe Lofgren, even though is the architect of this bill, he didn't have to do much fighting in the House. She had a good support. Maybe it's her captaincy that took where she had a support of 365 versus about 65 people opposing the bill. So going into the next Congress, especially the House, we're not expecting much problem. It's the Senate that we are expecting a lot of problem.
I've seen some questions about downgrading from EB2 to EB3, whether it's safe and whether it's advisable, even if your priority date is not yet current according to the filing dates chart. Yeah, so we've discussed this before. Downgrading from EB2 to EB3, there's no problem. We've done it several times in the past, and especially for Chinese nationals, that has been a very common practice when the priority dates for that category were in a similar situation before. So it's very straightforward and simple to do. We filed a lot of them in October. If your priority date is not yet current according to the filing dates chart, it's not necessary for you to file the downgrade I-140 right now on its own. It can always be filed concurrently with the I-45 when your priority date does become current according to the filing dates chart. But there's no harm in doing it on its own beforehand. So it'll be one less thing that you need to do in within a 30-day period during that month of the visa bulletin if your priority date is current. So there's no harm in doing it ahead of time, especially if your priority date is around 2015, 2016, and you want to go ahead and get started on it.
Mahesh has this question that the I-131 instructions has that the advance parole is not a guarantee for admission. What do you say? Do you see any rejections of the port of entry? Mahesh, nothing is guaranteed for admission, but if you're going to ask me that out of 1,000 people or out of 10,000 people, how many people do we see any problem entering into the United States in advance parole? Out of the 10,000 people, I would say about 2 or 3 or maybe 4. And most of these people have some history of criminal records, or some of them, they may have got this advance parole approval when they're outside the country, which is not to be used. The person needs to be there at the time of filing an advance parole. They need to be there at the time of they getting the approval. So these are the technical things. If you meet those requirements, though, we do not see much problem at all for the people who are at the port of entry. Jolly Male 121 from YouTube has this question. How to check the I-140 has been withdrawn, active with the previous employer? The best way to check is that by filing a Freedom of Information. You can go to Google and type in FOIA, Freedom of Information Act, USCIS. You will get a form there. If you fill a form, and you can fill it online, it will take about 3 months for you to get the copy of the entire I-140 petition, which will tell you if it's been withdrawn, if it is withdrawn, when it has been withdrawn. This is the only official way of knowing. The unofficial way is obviously you can call the employer. That's another way. The third way is that you can go online and check your status, whether it's been withdrawn. But those are not official. The official way is only by going and filing a Freedom of Information. Let me tell you one thing. It takes only 10 minutes. There is no filing fees, and you can do it online.
Yvonne from YouTube is asking if there are any chances for EB3 priority dates to move even further this year. His priority date is in 2016. So we actually don't really expect the filing dates chart to move any further ahead for the rest of this fiscal year, which lasts until until the end of September 2021. The reason for that is that the filing dates chart, kind of the whole reason for it and the reason why it is almost always ahead of the final action dates chart is that the filing dates chart, those dates are where the Department of State expects that the priority dates in the final action dates chart, Chart A, that's where they expect the dates will be at the end of that fiscal year. So by the end of September 2021, the Department of State expects that Chart A and Chart B will kind of be along the same lines. And that's the whole reason for Chart B, to allow people who will be eligible for the green card in that fiscal year to go ahead and start filing them so that they can be processed and they can theoretically receive the actual green card by the end of that fiscal year. In reality, those processing times, like we discussed before, are going to be most likely a lot longer than that. But for that reason, we don't really expect much more forward movement in Chart B. There is likely going to be movement in Chart A to try to catch up or get closer to Chart B. Due to the continued closure of the consulates around the world right now due to COVID and the continued executive order, there could be more family-based visas available, and that spill over the same way they did this past October. So even though there might not be that much more movement between now and September, we may see another kind of pretty big step this upcoming fiscal year in October 2021.
So in September, we will get the visa bulletin. So please keep the hopes up high on that a little bit. People are asking different questions now since the bill is dead. We may have a different session on that completely alone. Emily and I may present on that, but let me answer a couple of questions. Can the Joe Biden administration not count the dependents on the 485 application? I don't know. That need to be looked into. Mr. Venkat Bala will look into that, whether or not they can. But don't assume that Joe Biden is going to just come and give us switch so easily, though. He was not being regarded. We used to call Obama administration the deportation king. So don't expect this guy to just come and give the things to us so easily. It can be looked into it. There are also other things that the administration can look into, other than what you have said, that not counting the dependents. They can also look into the unused green cards, though. They amount around 250 to 400,000, depending on how you count. These are the things where previous to 2002, the per country limit was very strict. That means that if you meet the per country limit, they will never be given more than 7%. But in 2001, 2002, they changed the law that if no other country is taking it, they can be given to the country that is taking more than 7%. It's like this. There's a buffet. 1,000 people are there. No single country persons can go more than 70. So if more Indians are going, after 70 previously, they didn't used to allow. What they used to do with the rest of the food? They used to dump it out. Starting from 2001 and 2002, what happened was that because of the change in the law, what they said was that the wastage green cards could be given to the 7% countries. So that's the reason the Indians got more green cards between 2002 all the way to about 2008, 2009. Then what happened? The other country demand went up. So the people who are 7% got lesser and lesser. So there are some wastage that happened before 2002, all the way from 1992 to 2002 in the 10-year period. There are a lot of wastage. It is between 250,000 to 400,000 green cards. Yeah, that can be bought in. As Venkat, you have pointed out, the administration can look into the matter of not counting the dependents, because that's going to open up from 140,000, it will go to 280,000, actually 300,000+, which is going to be very good. They can give extra green cards that were being wasted out. Those are the other things. And there is also a third relief that they can consider, which is easier, which will not get beaten in the courts or anywhere, is the one allowing the I-140 people to file the adjustment of status and let them move from company A to company B on EAD. That will be the easy step that they can do. Yeah, they can explore the other two steps too, but this will be most easiest step that they can do, Mr. Venkatara Bala. Dazak has this question: can the U.S. citizen children sue the U.S. government for discrimination against the parents? That is called standing. That means that what standing do they have? That looks to be a very weak argument, though. It is not their birth, it is their parents' birth. Let the parents argue their own thing. That's what the court will come out to. That's my opinion, but can be explored more further. I'm not that good as a constitutional expert, as much I normally am better in immigration as compared to other things.
There was a question from someone who is waiting for their H-4 EAD to be renewed and asking that if they don't get it in time, can they use their EAD that is based on their pending I-485 application. So technically, yes, but you just need to be careful and probably discuss with the attorney who filed your I-485 application before going forward with that. If it was an I-485 filed concurrently with an I-140 downgrade in October, then if you've heard our videos before, we've kind of warned about the risks of getting married to an EB3 category, basically getting locked into the EB3 by using the EAD or AP that you receive based on that pending I-485 application. So if you want to leave yourself, if you are in that situation and you want to leave yourself the option of using an EB2 priority date in the future, then you'll need to be very careful about that. You won't be able to actually use that EAD from the pending I-485 application. You and your family will need to maintain age status in order to leave yourself that option available. Someone else was asking a question about using an I-765 receipt notice as proof of employment authorization based on USCIS policy. So there was a recent USCIS policy that said that because card production of the EAD cards has been delayed and backlogged for a very long time this year, for employment verification purposes, people who have had their I-765 application approved and they've gotten the I-765 approval notice, but just not the actual EAD card, they can use that I-765 approval notice as proof of work authorization and either continue or start working based on that without having the actual card in hand. But that's only if your I-765 application has been approved, not if it's still pending.
Questions about the consulates in India opening, though. They are not fully functional right now. I've been informed just now that they have canceled the February appointments that they've been issued. The March appointments are still open, but the February appointments are closed. We don't know how this pandemic is going to phase out. Hopefully the vaccine will come and get everybody better. I don't know, my personal experience in my home, because my wife is a healthcare worker, hasn't been that good with the vaccine at all. I hope she wasn't doing good at all once she took the vaccine. Even though me and my wife went through the COVID, when she got the vaccine, it didn't went through good. And when she called up her colleagues, all her colleagues, 4 of her colleagues had a different side effects. Now, this is my personal opinion. I'm not a healthcare doctor, but I don't know how this is going to be. Most of the consulates opening will depend on how the vaccine is going to work, depending on how the vaccine is high. I hope these are isolated situations. Things are going to still work. Maybe it's the other companies may work much better than this one. That's my hope. Side effects and other things are going to be better with other companies.
Upender is asking, so his degrees are in civil engineering, and that's what his current occupation is in, but he's interested in getting a position in data science in that field and asking whether he can move there. So you do have to be pretty careful about moving to a field that isn't pretty closely related to your degree program if you are in H-1B status. So there was that specialty occupation rule that has been put on hold, was struck down by the court, and that basically was very closely tying an H-1B beneficiary's field of study to the occupation that they would be doing. Even though that rule has been struck down, what we've seen in practice is that USCIS officers are looking for a pretty close relationship between the H-1B job and the field of study that you did in your degree program. So if you are looking to go into a data science field, I would say you will probably need an evaluation from an agency where a professor reviews your qualifications and determines that based on your work experience plus your degrees that you have the equivalent of a bachelor's or higher degree in a data science related field. And that usually requires at least 3 years of hands-on work experience in that area for a professor to be able to make that determination. So I would say you could probably consult with an attorney and review your background and see whether that might be a possibility. But without that sort of evaluation, I would say it may be pretty difficult to move into that field.
A lot of questions are here with regards to the EAD, Advanced Parole, H-4 EAD, premium processing. They don't exist at this point of time. The expansion of the premium processing has been passed in the Congress. However, the implementation has not been done. There is no mandate that they have to be implemented immediately, but we are expecting, since the new administration is going to come, they're going to start this because they have nothing to lose except gaining some money. So hoping that the new administration will implement it very soon. Questions come on a domestic violence issue. Any domestic violence been committed or even we've been arrested, though, this is a very, very serious crime. Even though you may have been, even though the case has been dropped, you may still be punished for it because they will look into the police report and find out what exactly happened. The USCIS can make a different determination than of the criminal court. In the criminal court, you have more rights as compared to USCIS, because USCIS, CBP, or even the consulate, because these things are considered civil, so you have lesser rights in here. So based on the reports there, even though the prosecutor has dropped your case, there is a chance that you may be excluded from this country. So anytime there is anything like that, you should contact a lawyer. Never try to take anything in your hand and do it by yourself once you have the domestic violence.
Vivek is asking whether he needs to extend his L1 status, which expires this upcoming April, if he has an adjustment of status application that was filed in October and his priority date is current. Vivek, I'm assuming that means it wasn't a downgrade application or an I-140 that was concurrently filed, that your priority date was current according to the final action dates chart, and you filed the I-485 application based on that. In that case, it is not as necessary for you to, be careful about getting locked in, because you're not trying to keep your options open between EB2 and EB3 in that case. If your priority date is current and the I-485 was filed just based on that, then it's much more of an option for you to use the EAD if it arrives before April 1st. So I would say that would be kind of the main uncertainty at this point, whether your EAD card arrives by April in time for you to continue work authorization uninterrupted without having to file an L1 extension. I would say that even if you are okay with just kind of not using the L1 anymore and just using the EAD and using that as the basis of your work authorization, you may still need to have your company file an L1 extension, because my suspicion is that it's very possible that the EAD still won't be available by April, unfortunately.
People are asking, hey, is it time to move to Canada or some other country with the HR bill, debt right now? Yeah, if I were in your position, though, I would do it. I mean, I don't want to keep coming to this weekly Tuesdays Facebook or YouTube and listening to the lawyers, and every time on my toes thinking about my H1 extension, H4 extension, whether or not I'm going to get it, whether or not I'm going to get the green card here, when I'm going to get it, if I'm going to be alive by the time I'm going to get the green card, if my kid is going to age out. Under all these conditions, if I were you, yeah, I would plan to move to Canada. I'm absolutely sure. If I were you, I would. As an immigration lawyer of United States, I'm telling that if I were you, yeah, I would definitely consider Canada as my option.
Sanket is asking if the wage regulation will apply to extensions also. So I think he's referring to the H-1B registration process that we were mentioning at the beginning of the hour. So no, that proposal that we were mentioning that would prioritize the level 3 and level 4 category wages, that would apply only to the H-1B registration process for selection in the CAP. So it would only affect first-time H-1B applications who are subject to the CAP applying in the lottery. It would not affect anyone who is already in H-1B status and needing to file an extension, transfer, amendment, anything like that.
Srivatsava from YouTube has this question. How frequently have we seen from L1B to EB1C? Is it doable? Yes, it is doable. It is doable. Rebecca, you have done some of them, is that right? Yeah.
Yeah, we've had cases like that. Mm-hmm.
So it's doable, but we need to look into very closely the job description that you had back home, and the future job description you're going to have here in United States. Based on that, yes, that can be. It is doable. It is doable. I would request that if you have any questions, consult Rebecca Chen in our office. She is we call L1A queen in our office.
Yeah, there's someone else asking about an upgrade from EB2 to EB1. So that is also possible. It depends on kind of your qualifications. If you're in the extraordinary ability category, it usually requires at least 3 out of a list of 10 criteria to be met. But sorry, I lost that question, but I think the person mentioned they have several Google Scholar citations, so that is something that USCIS definitely takes into account. So if you are interested in exploring the EB1 option, which would give you a lot of benefits as far as the I-485 process, you could consult with an attorney to go through your qualifications and CV and citations in more detail
especially if you have 100+ Google Scholar citations, as you mentioned. I would definitely try to go for EB1. Whether it's going to be EB1A or EB1, mostly it looks like EB1A would be more ideal. Especially if you're in the software profession, you should try more EB1A. It seems that you have MS in computer science, so that looks like you are, should be suitable for EB1A rather than EB1B. So that should be your, you should do that. You should try to do that. The question that pops up is, hey, can I do from L1 H1 to L1A if the role matches? Well, there's another thing that is a problem, Rajdeep. What we need to look into, there are two roles here. One role is your future role, but there is also, you must have worked for the same company, I mean the sister company or same company, there are some restrictions with that. You must have worked for that company in your, previous to coming into United States, or 3 years, you have to work for 1 year outside the country. That is an absolute requirement. You can't waive it. So if you have not worked for that company before coming into United States, the answer is simply no. You cannot do the L1A. The previous caller was asking about L1B to L1A. He already worked for the company for at least 1 year. Otherwise, he wouldn't have got the L1. He wouldn't have got the L1B. In your case, you are an H1B, so I don't know whether you worked for the company or not before.
Sachin was asking if it's worth it to have his company file an EB3 downgrade for him when the company that filed the PERM in 2016 was acquired by his current employer. So it is definitely possible to still have the new company, the company that did the acquisition, file the I-140 if there was a successor and interest relationship between your original company, the one that filed the PERM, and your current employer. So you would need to discuss with your company. Most likely, I'm thinking if you have continued working for the company that acquired your previous employer and they didn't have to do an H-1B transfer for you, if you are on H-1B status, then most likely there is a successor and interest relationship. And if that's the case, then the new company can file an I-140 based on the existing PERM. They don't have to go through the PERM process for you again if you want to do the EB3 downgrade. They just need to agree to file the I-140 petition, which they still do need to agree to that. But when they don't need to go through the PERM process again, it's relatively minimal effort that they have to put in to do the EB3 downgrade.
Pratap is asking this question. The Dropbox eligibility, is it 1 year or 2 years? What he meant to ask is that if you have obtained a visa of H1, H4, L1, L2, and some other visas also, you could go to India and you don't have to go for the interview. You can do in a Dropbox. With the interview, they normally give the approval. So that limitation used to be that your previous visa must have been expired by less than 1 year. However, recently because of the pandemic, Pradeep, they did change the timing from 1 year to 2 years. So if your passport visa is expired within 2 years, you are still eligible within 2 years, not beyond 2 years. You're still eligible for the Dropbox. Anything else, Rebecca, before we?
No.
Thank you very much, guys. I'm sorry it's a disappointing year. Let's start the next year. I mean, maybe better. The new administration is going to come. Let's keep the spirits high and thank for the people who have fought the battle along with us and fought well.
Yeah, thank you.
Thank you.